New at 5, the Oklahoma Supreme Court says it will determine whether or not a vote on recreational marijuana will be on the ballot during November's general election.
Fox 23's Rick Marinon is live to explain why, even though enough signatures appeared to be collected on a recent petition, Rick, the state says it's too late.
Well, supporters of recreational marijuana say they did everything right and that it's the state's new third-party vendor that verifies signatures is why there is now a question of whether or not this thing will make it on the ballot in November. Supporters of recreational marijuana will make their case before the Oklahoma State Supreme Court next month that their hard work to get it on the November ballot shouldn't go up in smoke.
This is an issue that has brought together people that are Republicans and Democrats and independents from all 77 counties and ages 18 to 102.
Fox 23 showed you back in July when supporters of State Question 820 submitted more than enough signatures to get recreational marijuana up for a vote this fall, or so they thought. The state is now using an outside third party to verify all signatures on all ballot questions, and the process took longer than expected. So when the signatures were verified, supporters of 820 were told by the state election board it was too late. The printing deadline for November ballots had passed.
We've always had the goal of being on the November 2022 ballot, so we are running full steam ahead, continuing to talk to people about the issue. What we want is for people to get to vote. Supporters will have to wait for a 10-day challenge period to wrap up, but supporters of 820 say they've crossed every T and have dotted every I. We feel pretty confident. There's two possible challenges that could occur in this 10-day period. One is to the signatures, and we have internally audited and validated those signatures multiple times. As far as any challenges to the ballot title, again, we were very pleased with the ballot title that Attorney General John O'Connor wrote. The state election board says it does not comment on pending litigation and would not answer questions about what happens if the state Supreme Court requires something to be up for a vote in November after the ballot printing deadline had passed. So in that 10-day challenge period that we're in right now, when we're talking about challenges, it isn't, well, I challenge this because this is how I feel. You actually have to have a legal or specific reason as to why this may violate the law when it comes to challenges. Any challenges that are deemed frivolous could face serious fines for wasting the time of the election board, the Secretary of State, and anybody else involved with the challenge process. Live covering news that matters, I'm Rick Marinon on Fox 23 News.